A very good evening to you, ladies and gentlemen. I am happy to welcome you to the fifth webinar of Series 6 on Basics of Law, titled Money Recovery under the Debt Recovery Special Provisions, Act Number 2 of 1990 as amended. This is the 30th BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the Chairman of the Webinars and Legal Symposiums Committee and the President of BSL, Mr. Rajiv Amarasuriya, the Co-Chairman, Mr. Chatra A. Galhena, Secretary of BSL, and Mr. Pasindu Silva, Treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSL for all the support and guidance. For today's webinar of Money Recovery under the Debt Recovery Special Provisions Act Number 2 of 1990 as amended, we have with us an esteemed panelist, Justice Priyantha Jayawardena, President's Counsel, and former Justice of the Supreme Court. After completing his primary and secondary education at Nalanda College, Colombo 10, Justice Jayawardena entered Law College in the year 1985. Thereafter, he was called to the bar and enrolled as an attorney at law of the Supreme Court in the year 1988. While he was in private practice, he also worked as a research assistant to the late Justice Mark Fernando and the late Justice P. Ramanathan. Thereafter, he joined the Attorney General's Department to work in the Government Institutions Division in the year 1991. Later, he proceeded to the United Kingdom and obtained a master's degree in commercial law from the University of Aberdeen in 1993. Justice Jayawardena also passed the Qualified Lawyers Transfer Test conducted by the College of Law in the UK and subsequently enrolled as a solicitor in England and Wales in October 1996. Upon his return to the island, he joined the Attorney General's Department and served as a state counsel and reverted to the unofficial bar in the year 2000. While serving at the Attorney General's Department, Justice Jayawardena worked as a consultant to the Ministry of Food, Internal and International Trade and Commerce. During that time, he prepared the initial draft of the Consumer Protection Authority Act No. 9 of 2003. Justice Jayawardena also served as a member of the Advisory Commission on Intellectual Property Law in Sri Lanka. Further, he served as an examiner for the Council of Legal Education. While in private practice, Justice Jayawardena served as a member of the Advisory Commission to the Intellectual Property Office, the Securities and Exchange Commission of Sri Lanka, and the Core Group on Information Technology, which was instrumental in drafting of the Electronic Transaction Act No. 19 of 2006. He also functioned as a director of the National Savings Bank and the Lanka Electricity Company. Further, he was also a visiting lecturer at the University of Moratuwa. Justice Jayawardena was appointed as the President's Counsel in the year 2012 and was elevated as a judge of the Supreme Court of Sri Lanka in the year 2014. Subsequently, he was appointed as a judge of the Supreme Court of Fiji and functioned concurrently as a judge in both Supreme Courts. He was also an ex officio member of the Council of Legal Education and the Judicial Service Commission. Presently, Justice Jayawardena is functioning as the chairman of the committee to review the existing insurance laws of Sri Lanka. I warmly welcome Justice Priyantha Jayawardena, President's Counsel, for today's session. To moderate today's session, we have with us Mr. Shehan Gunawardena. Mr. Gunawardena is an attorney at law of the Supreme Court of the Democratic Social Republic of Sri Lanka and was called to the bar in December 2002. He had his primary and secondary education at Trinity College, Kandy. For the last 22 years, Mr. Gunawardena has been specializing in drafting and vetting corporate agreements between local as well as multinational parties, all types of civil litigation, including money recovery, land, company law, banking, intellectual property law, delictual claims, leasing and finance, and labor, and providing advice on incorporation, corporate restructuring, and winding up. Mr. Shehan Gunawardena also served as a consultant on commercial law reforms at the Ministry of Justice during 2020 to 2022 and served the Bar Association of Sri Lanka as a co-chair of the CPD committee and chair of the Apprentice Training Committee in 2024-2025. He was also a member of the Executive Committee of the Bar Association for the years 2024-2025. Mr. Gunawardena is a visiting lecturer and examiner at the Sri Lanka Law College and appears as junior counsel to Mr. Harsha Amarasekara, President's Counsel, who has an extensive practice in commercial law and litigation. I also warmly welcome Mr. Shehan Gunawardena, attorney at law, for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you, sir.
Thank you very much, Isuri. And it is an absolute pleasure, if I may say so, at the very inception that I was invited to moderate this webinar on a very important and current topic. And I am honored that the speaker is a renowned and well-respected Judge of the Supreme Court, retired Justice Priyantha Jayawardena, President's Counsel. And to his credit, I know, sir, that in your tenure in the Supreme Court, close to 1 decade of service, every day you came on to the bench having read all your briefs. And that is an absolute credit to you. And we had the pleasure of appearing before you when you adorned the bench of the apex court of this country. And given your very colorful career, meaning that you have had varied experiences in the corporate sector in Sri Lanka and judicial experience even outside Sri Lanka, having served the judiciary of Fiji, I think that one area that you consider which is important to the commercial sphere of Sri Lanka is the recovery of debt given to the public by institutions. Now, sir, this is a topic which has been controversial right along with the introduction of every statute that empowered the courts or empowered the financial sector, the players in the financial sector, to use measures which some called extrajudicial methods of recovery. It has always been controversial, and even some have called it draconian. However, before we get into the meat of the topic, sir, it would be good for our listeners to understand how the law relating to recovery of loans came to be. What was the landscape that prevailed at the time these were introduced, sir, from your experience and from your reminiscences of that time?
Thank you very much for the very kind words expressed by the previous speakers. Though I don't know whether I deserve all that. I think in my presentation, I will address the points that are useful for the legal officers of and other persons who are involved in the recovery process for financial institutions, and also who are appearing for the litigants, namely the debtors who have taken loans. So I will deal with both aspects. So to respond to the first, the answer posed to me, as you all know, with the expansion of commercial activities, initially people used to borrow money from individuals. So those are from people within the family, from the extended families. Then there were mudalalis who were lending money, and various things took place. So after little by little, the lending institutions were established. So then people went to the lending institutions because they were more reliable. But the question arose, how the lending institutions can recover this money. So initially, we resorted to the Roman Dutch law to recover money. So there is a landmark judgment, but that is also in our civil law ordinance, where it says that you cannot recover interest that is more than what you have obtained as a loan, or the principal sum given as the loan. So thereafter, so that was initially it was in the Roman Dutch law, but that was codified. Then if I remember correct, 1890, the Civil Procedure Code was enacted. So in the Civil Procedure Code, we incorporated provisions to recover loans. So there are two types of procedures that are used to recover loans. One is just a regular procedure. Other one is the summary procedure. But for example, we use summary procedure to recover money given on checks, security like checks or various other things. So those provisions are there, but then the issue arose, those cases were taking a very long time, and also with regard to burden of proof. So when you file a regular action, the burden is entirely on the plaintiff to establish every ingredient or the part of their claim. So as a result of that, some were using summary procedure whenever it's possible. But there was a lot of agitation by the financial institutions, the loss delays. So we must keep this in mind. When a person, including us, go to a bank to get a loan, their interest rates are very high. But if you compare a developed country, the West, for an example, their interest rates are very low, lending rates. Why? Because our default rate is very high. As a result of that, and also we must keep in mind, the money advanced by the financial institutions are raised by the public funds. So those are depositors' money. So as a result of that, depositors also won't get a reasonable interest for their deposits. Plus, because of the default rate, the financial institutions absorb that and increase the rate. So if somebody is defaulting, you are paying that money by way of interest. So therefore, there was a lot of agitation by the financial institutions, and then the government, but by that time also, there were various loans, the acts. Now, for example, Bank of Ceylon Act, People's Bank Act, Mortgage Act, and Development Finance Corporation Act, which provided a special procedure to recover money. So then, the other banks and the financial institutions were making a big fuss, saying certain banks are at a privilege and which we don't have. And as a result of that, they wanted to have similar procedure to recover the money advanced by them. So that gave birth to this more the recovery of loans by banks, Special Provisions Act number 4 of 1990. Then Debt Recovery Special Provisions Act number 2 of 1990 and subsequent legislation. So that is our history. But now, before I get in, we get into the main topic, that is Debt Recovery Special Provisions Act. I will briefly explain this only, that now there are instances where persons go and get loans from various financial institutions, and they want to recover this money under Section 12 of the Recovery of Loans by Bank Special Provisions Act of 4 of 1990. So there, the threshold is 5 million. Now, there was a time where there was an ambiguity. How we are going to calculate this 5 million? Because that 5 million should be the principal amount. You cannot add interest or penalties and say this and also 5 million should be the principal amount that was lent. Then the question arose. Now, for an example, there are instances where I go to a bank and borrow 7 million and I give a movable property as security. So then by sometimes I may have paid 4 million. But so then the balance is 3 million. Then what happens is I go to a bank, I borrow, we say I borrow 3 million. Then then I pay 2 million. Then I go to the bank and get, because now they will consider me as a good customer. Then I will ask for another 7 million. Then halfway through I default. So how do you calculate the principal sum? So the principal sum would be calculated by considering the total sum lent by the bank, notwithstanding the fact that you have paid part of it. And also there is in that act, there is a provision where you may have defaulted one loan, where you have, we say you have obtained several facilities. But if the bank wants, they can institute action under this act with regard to all the loans. So that is a unique provision that is available in this act. But we might feel that is very unreasonable, but we are only dealing with the interpretation of the law, but not the policies of the government making this legislation. But the main issue is to recover money. So we must keep in mind what I said earlier at the very inception. We need to minimize the default, because if you can't do business if there are default. So you need to recover money, and they are also doing a business, and that is how economy works. Yes. So can I proceed to the other one, or you want to pause?
If we can,
So if you
we...
want, you can share this judgment. That is
Yes.
SC Appeal 44 of 2015, one of my judgments. If anyone wants, they can have access to it.
We'll just give the reference, sir, because it is we can access
SC
it from the
Appeal,
Supreme Court website.
SC Appeal number 54 of 2015, delivered on 14th of November 2022.
Thank you, sir.
Mr. Harsha Amarasekara PC appeared for the defendant appellant. Dr.
Yes, that's
Sunil
it.
Kure appeared for the plaintiff respondent.
Thank you, sir. Sir, if we can now move into the topic particularly for today, that is the provisions of the Debt Recovery Special Provisions Act number 2 of 1990. There seems to be, practically, sir, in the courts today, there seems to be a renewed interest in this act and the provisions of this act, where financial institutions seem to be moving towards instituting action under the provisions of Debt Recovery Special Provisions Act to recover their outstanding debts, and they feel that that seems to be a faster approach to recovery. Therefore, the number of cases being filed is increasing, and both sides of the bar table, that is the plaintiff's lawyers and the defendant's lawyers, would both, I believe, be equally benefited by your lordship taking us through the provisions of this act so that everyone is clear on what can be done and what cannot be done under this act. So if I may invite you, sir, to firstly take us through the provisions as to who can institute an action under this act.
Yes. Yes, before I come to the act, let me say this. Financial institutions earlier were resorting to the other legislation. One reason is they can recover the penal interest and also penalties. But there were a lot of delays because those cases were taken up for trial along with other cases, and also there were a lot of difficulties in serving summons. Even if you serve summons, the defendants will come and file answer with a bare denial of all the averments. You know, a lot of people do that in the district court, not only banking matters, other ones also, they just a bare denial. So entire burden is on the financial institution to prove that. And also a lot of frivolous objections are taken. Now, when you resort to the Debt Recovery Law Act, the special provisions, straight away it's a summary procedure is followed, and the order nisi, I will deal with them separately, order nisi would be issued. So then the defendants will have to appear and get permission of court, like in other summary procedure matters, to appear. So I will deal how it gets and how difficult it is to get obtained. And also there are many instances where they will have to deposit money. When this law was enacted, most of the people, including the trial judges, thought that the defendant should deposit the total sum in order to get permission of court to appear and defend the action. But later, the courts relaxed that and they said, all right, you deposit 50% of the claim. Then it came to 1/3 because lawyers were very clever in persuading the judges to be more lenient, and they are with their charm. So then the judges were very lenient, and then the amounts were reduced. But there are 2 judgments where I have written, and as a result of that, I was told now the banking court and the other certain district courts in the other provinces also are using those judgments. And if you establish that there is a good defense, you can even appear without depositing any security. Now, for an example,
that means unconditional leave to appear.
Yes, that's right. So that's the background to this act. Now, responding to the answer posed to me, I will read this section 2. I think that's the answer is in that. It says a lending institution may, subject to the provision of subsection 2, recover debt due to it by an action instituted in terms of the procedure laid down by this act in the district court within the local limits of whose jurisdiction it goes on to say a party defendant right, a cause of action arise. Then like that, it goes on to various other provisions. So now also it says, this is important, it says principal amount lent or advance was less than 150,000 rupees. So that is 150,000. So if it is below that, you can't go to that. And also remember, it is the principal amount. That is not including the interest or the penalty or whatever. Anyway, various other things. Now, the important thing, there are important things that have been incorporated into this section. It says a lending institution.
Yes.
Now, if I borrow money from one of you, I won't be able to go invoke the provisions of this act. It has to be a lending institution. So then, lending institution is defined in section 30 of this act. It says lending institution means a licensed commercial bank, then state mortgage bank, national development bank, national savings bank, development finance, a company registered under the Finance Companies Act. So then as a result of that, all finance companies are also coming in, not only licensed commercial banks. But then it also says, this is very important, recover debt due to it by an action instituted in terms of the procedure laid down in this act. So that is very important. You have to comply with the procedure that has been, that is section 2(1) says, you have to follow the procedure laid down in that. So then you can't resort to the Civil Procedure Code or any other law. So section 4 stipulate the procedure that the action can be filed, how the action should be filed. And also for the lawyers who are from Colombo, I want to say this, irrespective of the amount, even 50 million, 100 million or whatever the amount, the jurisdiction is not with the Commercial High Court, but with the District Court. So then we in Colombo, we have a special court which is called as Banking Court. That has been there for very long time. As a young state counsel, I used to appear in that court because I was a member of the banking unit in the Attorney General's Department at one point of time. And especially section 2, it says, no action shall be instituted by an institution in terms of the procedure laid down under this act for the recovery of a loan. So it's a mandatory provision which needs to comply with that. So that's the threshold and the jurisdiction of the court. Then we come to how the action has to be instituted. Section 4. Am I to proceed with that? Or?
Yes, sir. In section 4, sir, if we look at the provisions, sir, the requisites of the plaint are set out, and it says shall be accompanied by the affidavit and the instrument or agreement or document sued upon or relied on by the institution. I wonder whether you could elaborate on that, sir. What is actually required to be annexed to the plaint?
Yeah. Now, section 4 says action has to be instituted by way of a plaint. But unlike now, as you know, in a regular action, you don't annex documents other than the agreement that you are going to, if you are going to sue, under section 50, otherwise you
Section
won't be
50
able to
of the
produce
civil
that if you
procedure.
don't annex it. And it's mandatory to annex that. But
Yes.
under the special law, there are certain things that you have to annex because the judge will consider, because whether to issue order nisi or not depends on the documents that you file. And this stipulate what are the documents that you have to file to satisfy the judge. And here you have to annex a draft. You have to support the averments in the plaint by way of an affidavit. That is the initial thing. For the do you know why we file an affidavit? Because affidavit is also is evidence. Because judge needs evidence to consider whether this is a fit and proper case which needs or which warrants to issue an order nisi.
May I interject
Yeah,
there, sir? Although
yeah,
Section 4 says affidavit, and
yeah,
as you correctly pointed out that the affidavit is the evidence before court, and
yeah.
if there is evidence that supports the averments that are set out in the affidavit, then those also necessarily might need to be annexed to the affidavit. Would that be
Yes, yes,
correct, sir?
I will come to that. This section itself stipulate the document that are required to be annexed to the affidavit. Then also it says you have to file decree nisi, draft decree nisi. And remember, then the instrument or the agreement or the document sued upon or relied upon by the institution. So, I will give that reference. I have written a judgment on this matter also, where the threshold is there has to be a written document between the borrower and the financial institution. If there is no document, it's not possible. And the courts have held a promissory note does not come in within this provision. And also I have held that giving an overdrawing an account without an agreement would not trigger this act. So there has to be a specific written document where you need to produce. Now, when you annex these documents, especially the lawyers who are appearing for the banks have to be very careful. More often than not, we don't stamp those documents at the time of execution. For some reason, we miss that. Now, in other cases, if we file that in court, with the permission of court, you can stamp it. But here there is provision which says, subsection 2, if any instrument, agreement or document is produced to court and the same appears to court to be properly stamped and not to open to suspicion by reason of any alteration or erasure or any other matter on the face of it, and not to be baited by prescription, the court being satisfied the contents of the affidavit, then it goes enter decree nisi. So that is the danger. If you have not stamped, then it's not possible. And also we must keep in mind that once the papers are filed, that is the plaint supported by an affidavit, it is not possible to file additional paper or material at the time of or before the inquiry before the inquiry. That is after or any or when the defendant comes and files an application to seeking permission to appear and defend the case. So it's out. So this is a one-shot application. So in the first round itself, you have to be very careful to include all the documents that that are needed to satisfy the judge to issue order nisi. So, and also remember, like the similar provision is in the civil procedure code also for regular action and like that, you need to file sufficient number of sets to be served on the defendants. So that is also should accompany at the time of institution of the plaint. So those are the main matters that you need to file it. And then also this says, now if you look at section, you go back to section 30, it says the affidavit, it defines who is a principal officer, because that affidavit, supporting affidavit should come from a principal officer. Section
Yes.
30, the last interpretation,
Paragraph.
it's in principal officer, it says in relation to an institution means a director, secretary or other officer not below the rank of a manager of such institution, and shall include any other officer of such institution specially authorized by such director, secretary or officer not below the rank of a manager. So if you are coming under the last category, it says shall include any other officer of the institute specially authorized. So you have to file that letter of authorization also along with the affidavit. And it is very important that the affidavit must say that the money
Section 4.1, sir, I believe you are trying to refer to.
Yeah.
That it's lawfully due to
it says that's right.
4.1.
Thank you. It says some claim is lawfully due to the institution from the defendant. Now, the bank, the person who filed this affidavit run the risk of charging for perjury also. Because
That's
if
right.
you file a false affidavit, then you say that money is lawfully due to the institution. If when it comes to the seeking permission to appear and defend, if you can show that you have paid the money, so then it's a false affidavit. And also, if the amount stated there, or if you have paid more than what is stated in the affidavit. But the danger is if you say the balance is due to the financial institution, the court will ask you to deposit that money to give permission to appear. And there's a judgment to that effect. If you admit part of the claim, then you will have to deposit that money to get leave to appear. Hmm? So that is the danger in filing a false affidavit.
And also, sir, if I may draw your attention
Yeah.
to section 11, sir, which says that compensation can be awarded to the party prejudiced if you have willfully suppressed or not disclosed relevant facts.
Yeah, exactly. So there may be instances where sometimes the way that certain documents they might attach or for vague or false averments can be included in that. So that also can be challenged when you file your application. And also I want to say, a lot of people say we file objections. That is wrong.
Hmm.
What we file is an application. So in the
We-
application, you can take up all those things, and we will discuss that when we come to that section.
Yes.
Hmm? And also remember, section 4, subsection 4, it says, if the court warns, shall be liable to be examined as to the subject matter thereof at the discretion of court. That's the very end of the section 4.4. It says it gives permission for the court to consider that. And now we will, so now we have discussed how this application is filed.
Yes.
So then what happened next? Once an application is filed, a counsel will have to support that application before the court. It's not automatic. The courts will not issue a decree nisi as a matter of course. So you have to satisfy court that there is a good case or strong case that warrants the issuing of order nisi. So there it is there are a couple of judgments. Actually, I also wrote a judgment on that matter. I think the reference to that matter is SC appeal number 4 of 2015. I will repeat that. SC appeal number 4 of 2015, dated 2nd of April, sorry, 15th of September 2020. 15th of September 2020. So there I heard that the courts will have to judicially evaluate the documents that have been filed by the plaintiff along with the affidavit and satisfy that there is a prima facie case to issue a decree nisi.
Decree nisi.
Now, there are certain instances where certain financial institutions or including banks, they file, like they have the practice of filing all other different plaints under different laws, and where they claim penal interest and also penalties. So if you include those things, we will say we will come to that, because this act does not permit to include such reliefs. So the court will not issue decree nisi. So you need to be very careful not to include those things in your prayer and also supporting in your supporting averments. So then what you can claim is the principal or the outstanding sum and the interest or the accumulated interest on the principal sum.
So that is referred to in section 21, 22, and 23 of the Act, sir.
Yeah. Yes, section 22, it says no sum of money which constitutes a penalty for default in payment or delay in payment of the debt shall be recoverable in an action. So therefore, so it's not possible to recover. And also, so now, so now we have come to the stage where the plaintiff will support and the judge will issue order nisi. So once the order nisi is issued, what are we going to do? Then we have to serve the decree of decree nisi on the defendants. There are several methods stipulated in the Act. In terms of section 5, you can post it. So if you post it, then the question arises. Subsequently, you will have to file that the proof that that it was served on the defendants. So here, like in Civil Procedure Code, you can serve it at the residence or in the office or where the workplace or various things are provided here. Then section 5B says you can serve it, that came by way of an amendment through a process server. I think that is a safer course of action. And also, as we know, all of us know, that once once they receive a registered letter, so they get advance notice. So then they will try to avoid the process server. And they will bribe the person who tries to deliver the letter also, and avoid sending the letter saying that it was delivered to the defendant. So straight away, if you resort to section 5B and get the process server to serve it, so then it's a better way of handling the situation. So they have interpreted, the Act interprets section 6 says, in the same section, subsection 6 says process server means a fiscal officer of court, and it goes on to say Gramaniladari and various other officers. So and also it says private server, those are difficult provisions. So better not to resort to those ones, but then you serve it. And then also it says you must give sufficient time, depending on the area that they live, to give to decide on the notice return or the summons returnable date for them to come and appear. Now, we say if the defendants are not in that same jurisdiction, so you will have to get the judge to serve the decree nisi through the relevant district court where the defendant is residing. So that will take some time. So here from this send it, you have to send it, and also from there they have to go and serve and then submit a report to the respective court. That will take a fairly long time. And our problem is the instructing and the counsel will support the matter. So then the duty will shift to the instructing attorney. Our instructing attorney should go to the office and follow it up. Otherwise, nothing happens. Even on the next date, the summons may not have gone, or the decree nisi must be just lying there. So, so those are the main reasons for the delay in disposing matters. So then the instructing attorney must go and then make sure that the decree paper, the decree nisi is dispatched. So now, then we come to the section. Before that, I will briefly discuss with the with the same in this judgment, SC Appeal number 4 of 2015. And also remember the debt is defined in section 30 of the Act.
30.
I don't want to read that because of the time
Yeah.
constraints. So you all can look at it. And
So while you're getting the reference
yeah,
from the document you're looking at, might I just announce to all the participants
yeah,
that you can refer questions in writing under the Q&A option that is
yeah.
there on the Zoom
All right,
screen.
okay.
Use the Q&A option and you can refer
Yeah,
your questions in writing and we will take it up during the
right,
Q&A part of this
right,
Zoom.
right.
Thank
That's
you.
fine. Yes, yes, please. You can make that announcement.
Yeah, I just did, sir. Thank you.
Yeah. Then because now section 4.2 says they have used the word the court being satisfied of the content contained in the affidavit referred to in subsection 4 shall enter a decree. So if the court is not satisfied, they can always refuse to issue decree nisi.
Yes.
So then the burden is on the plaintiff to establish that there is a prima facie case, and also you have complied with all the requirements that are set out in 4.1. So if you have not filed any of those documents, it is not possible. Then 4.2, it says rights of a defendant under Debt Recovery Act. So now when they receive the decree nisi, what can they do? Defendant, so the decree nisi specifically mention a date where they are required to come to court and obtain permission of court to appear and defend. So
I believe you are referring to section 6.1, sir, is it?
yeah, sorry, 6.1.
Yes.
Now the question is whether that is automatic. You can't appear in court. Now in the district court for in a regular action, that is your right to appear.
Yes.
Any defendant can appear as of right. But here it's not as of right. You have to get permission of court to appear. How long we have? We have another 10 minutes, right?
We can take a little longer, sir. That's all right.
Yeah. I will go a little fast.
So
So
now
then,
under this section, if I may just
yes,
interject, sir, usually the objection is taken, usually or not usually, sometimes we see the defendant's lawyer coming and asking on the notice returnable date, asking for time. They file the proxy and ask for time to file their application to appear and defend. Or sometimes they are under the misconception that they have a right to file objections. Can you elaborate on that,
yeah,
sir?
yes. Now, section 6.1 says, in an action instituted under this act, the defendant shall not appear and show cause against the decree nisi unless he obtain leave from the court to appear and show cause. They have used the word shall not appear. So then the question of you can't appear unless the court allows you to appear and show cause. Then it says now this says The court shall, upon filing by the defendant of an application for leave to appear and show cause, supported by affidavit, right? So that is why I said you don't call any other name, objections or answer. It's called an application. You make an application to for leave to appear and show cause, which has deals specifically with the plaintiff claim and state clearly and concisely what the defense to the claim is and what facts are relied upon to support it. After giving so then that is why I said you can't file a bare denial. So you have to come up with your defenses. What are your defenses? Why
Yes.
you should why you are saying that you should be allowed to appear in this case and also defend your action. So therefore you have to file an application and also supported by affidavit. As I said, affidavit is evidence, and also for that you can attach whatever the document that you have. Now, for an example, if the bank has given you a letter saying that you have paid the entire sum and your mortgage is discharged or something like that, or various other things, document that you have, or if you can show that that this action is prescribed. Now, coming back to the here this act says on the very first date that you have to file your application when you go to courts on the very first date. But in practice, the courts allow the lawyers to file a proxy and file and move a date to file an application to seeking permission to appear and defend.
So such leniency, sir, if I may add, would be within the
You
discretion of the
you are
court.
solely at the mercy of court.
Solely at the mercy of court. Yes.
Solely, it depends on the judge. So now then what are you going to do? Here it says, the act says section 6(2), after giving the defendant an opportunity of being heard, grant leave to appear and show cause against the decree nisi. But I will give I gave the reference in my judgment. I have said, though it says after the legislator has used the word the defendant an opportunity, you must give a hearing to the plaintiff also, for the reason that plaintiff is the one who supported the application. So otherwise that violates the principles of natural justice. So that is considered as judge-made law. And also, since this is a dracuna piece of legislation, so it's more for the then it's easy for the court also to take a considered view on the matter. So you you do it, you hear the plaintiff, counsel for the plaintiff as well as for the counsel for the defendant, in order whether to allow them to appear in the case and defend the action. And also with regard to the security that needs to be furnished, if at all. So, but it is very important to note, in the same judgment I have dealt with that aspect also. At that stage, it is not possible for both parties to file additional papers. So
Yes.
it applies not only to the plaintiff but also to the defendants. So defendants also should be careful when they file paper. They must file a complete set of papers, including the documents that they want to for the judge to consider. And also at that stage, it is summary procedure. No evidence can be led by both sides. So the judge will look at the papers and then decide whether to allow you to appear or not to allow you to appear. Then, because of the time constraints, I am not going to deal in this detail that all these things have been dealt in the judgment that I referred to. This says, 6C says, B says, upon the defendant furnishing such security as the court may appear reasonable and sufficient for satisfying the sum. Sorry, A says upon the defendant paying into court the sum mentioned in the. So now this is where we have to be careful. Initially, as I said, the court said you deposit the total sum, then said you deposit 50% of the amount pleaded, then it was 1/3, but now it's different. Because the courts have now, so the Supreme Court has interpreted section 6 to A, B, and C.
Yes.
A says if the defendant wants to deposit the total sum, courts have no choice but to allow them to appear in the case. So you deposit and say, no, as of right, I've deposited the money, I want to appear and defend the action. Defend. Because this is relevant when it comes to further later in that they say if you deposit that money, even you can dispose the property. Because
Right.
otherwise disposing the property is an offense when the case is
Correct.
pending after decree nisi is served.
That's
It's
right.
a criminal offense. So now then B says upon the defendant furnishing such security as the court may. You don't need to deposit money, the total sum by way of cash. You can furnish a bank guarantee or whatever the security that the court may consider. So that's a matter for the counsel to persuade the judge to accept or other security instead of money. Because sometimes your client may have money in the bank. So they don't need to uplift a deposit and come and bring it here. They might obtain a bank guarantee, irrevocable bank guarantee, and deposit that in court for the amount that may be determined by the court. Then we come to C. So there, the last words at the very end, it says, or otherwise as the court thinks fit. So that is the court discretion coming. When this limb of the section triggers in, the court can see, we say on the face of it, you have a good defense, prima facie defense. So what is defense is, you don't need to show that you will win the case. So there is a triable issue that the court needs to seriously consider. There is a matter to be looked into. That is sufficient. You show it on a balance of probability. So if that is the case, or on the face of it, we say some documents have not been attached, but by an oversight, the judge has issued a decree nisi, or it's not stamped, or the agreement is not signed by your client. So you file an affidavit, then you say, no, please let me appear, permit me to appear and defend without depositing security. So there, this or otherwise, as the court thinks court thinks fit, can be used to get permission to appear without depositing a single cent. So that is the your ability to persuade the judge that you have a good case or matter that needs to be looked into. So that is where so then you get the right to appear. So now this is very I would say very interesting phrase is included there in the same section 6 2C. It says framing and recording of issues.
Yes.
So that means the court will frame and record issues. Why? So then but here in section 7 it says if the defendant appears and leave to appear and show cause is given, the provisions of section 384, 385, 386, 387, 390, 391 of the Civil Procedure Code shall mutatis mutandis apply to the trial of the action. So basically chapter 101. So what they are saying is summary procedure. But
Yes.
then also this section 90 says in any matter or question of procedure not provided for in the Act, the procedure laid down in the Civil Procedure Code, Chapter 101, in a like manner or question shall be followed by the court if such procedure is not inconsistent with the provisions of this Act. So now, since this is framing and recording of issues, the words are there. So after that, the court will go into the evidence. So the plaintiff will have to read that affidavit in court in evidence and get someone to get into the box and give evidence. So at that stage, the defendant will get a chance to cross-examine and then the re-examination. So there will then the defendant will also get an opportunity to lead evidence and present their respective cases.
So basically, sir, if I
yeah.
may interject, it would be reverting or it would be moving to a regular procedure
Exactly.
from this
So
special
that is the
procedure.
same. That is the same in the
Summary
summary
procedure and the
procedure
civil procedure.
also. Yes,
Yeah.
we follow the same procedure. Then there is provision, and at the end of the day, the court will decide whether that is section 6A, whether to make the order decree nisi absolute or to refuse that. And also if there are several claims, the court can make it absolute part of it. So those are the ones. Then so there is also provision where if the decree nisi, if the defendant can show that is section 6A, if the decree nisi was not served on him, or if he was unable to come to court by reason of accident or misfortune, he can make an application to purge default before the same court and ask the court to set aside the order that made absolute, made the decree nisi absolute.
And that
But
is
only
within
thing is
reasonable
against
time.
that, yes, within a reasonable time. The other issue is, but only thing is there is no right of appeal against that judgment.
Yes.
It's the same under section 86 also, purge default, no right of appeal. Now, then you must, the other thing is, it's important thing in this act is, once a decree nisi is, or decree nisi is made absolute, you don't need to get another writ. So this functions as a writ itself. So
Yes.
that is a important thing in this act. And section 22, if you look at it, this says that this is what we discussed. No sum of money which constitute a penalty for default in payment or delay in payment of a debt shall be recoverable in an action instituted for the recovery of such debt in terms of the procedure laid down by this act. So that is what we said. So those things cannot be included in the prayer, and also no point including them in the averments of the plaintiff filed of the affidavit and the plaint filed by the plaintiff.
And sir, if I may draw your attention to section 23, sir, it
Yeah.
spells out that the interest that was agreed between the parties can be claimed.
Yes,
There
yes.
is no
That
provision
is
for
why.
legal interest or.
Yeah. So that is why this is important, that you need to have a written agreement. So if there's no
Yes.
written agreement, it is not possible. Court is not going to calculate this. In the same judgment, I have dealt with that. So court will not consider, not going to calculate it, because there is no provision, there is no material for the court to calculate it. And remember, this is not a regular action as such. So then the decree nisi, at the end of the trial, the court can do either you make the decree nisi absolute or refuse to do that. So
Yes.
if you say that certain part or the decree nisi is wrong, then the court can't do anything about it. Court can't alter that and sign it. There's no provision for that. But in the civil procedure code, there is provision for regular action. But this act doesn't have. So that is why you have to be very careful with the prayer. So you must have sufficient material. And also, in my judgment, I have discussed the accounts filed by the bank under section 90 C of the evidence ordinance. That is not considered as an agreement between the parties. That is not sufficient material to get a decree nisi, because there is no agreement. That's a unilateral document prepared by the bank, but they have given special permission under the evidence ordinance to file that, and certain powers are given to that document. So, but for Debt Recovery Act, it has no application, or rather it doesn't satisfy the requirement of having a written document, including promissory notes. So you have to have a specific written agreement, and the interest also should be there. Right?
So can we briefly look at the provision with regard to appeals, sir?
Yes, appeals. In the act, it says the Court of Appeal, but
Section 6.
but now with the new thing coming in, the civil appellate courts coming in, so now the jurisdiction is with the civil appellate high court. And also it says, now for an example, when there is an interlocutory order, you can, against an interlocutory order, for an example, with regard to ordering of security, you can file a leave to appeal application against that order in the civil appellate high court. But this section 16 stipulates that it is not possible for the court to grant a stay order to stop the proceedings in the district court. The
Yes.
district court will continue irrespective of the fact that there is a pending appeal. Any other specific question that you want me to answer on this appeals?
Yes, sir. With regard, yes, unless of course the section says sir, that unless the Court of Appeal specifically
Decides
directs
otherwise,
that
yes. Yes, the court has the
that the
discretion,
proceeding
but
should be
so
stayed,
then the
it doesn't
court will have to
automatically
give
stay.
specific reasons for that.
That is right, sir.
Hmm?
With regard to the appeal, sir, that I seem to have a question that has been posed, sir. That is, there is someone who wants to know whether if both parties like to enter a settlement before the district court, can they enter the settlement and enter the settlement decree?
Yes, it is possible. There is provision in the act itself.
Yes, sir.
It says you can
Adjustment of actions
waive.
is there, sir.
Hold on for a moment.
Section
There is
12,
provision.
sir.
Section?
Section 12.
Yeah.
Isuri, can we show the section? Possible? Thank you.
Yeah, that's right. It says where the defendant appears in court in response to a decree nisi and does not contest the decree but admits liability and pays to the liability, the court shall, with the approval of the both parties, minute the fact that records such settlement shall operate as a stay of execution of proceedings unless the defendant acts in breach of that. So it is there is provision for this. Under the section 12, you can enter terms of settlement. And also, I can't remember, there is a provision which says court can, as I referred to that, you can issue decree only to a part of the claim if there are several claims. Sorry, I can't just.
I believe you were referring to your judgment and you gave the reference, but some of the participants want to whether you could repeat that, sir.
Okay. One judgment is SC appeal. SC appeal number 237 stroke 214. 237 of 2014.
14.
Decided on 29th of November 2021. 29th of December 2021. Another one, SC appeal number 4 of 2014, decided on 15th of September 2020. And there is another one, SC appeal number 54 of 2015, decided on 5th of July 2023. 5th of July 2023. May I think if you can repeat, it would be better.
Yes,
because
I'll
you
do
are
that,
you are
sir.
more visible. Huh?
Thank you. I'll do that, sir. It's
Yeah.
SC appeal 237 stroke 2014, decided on 29th November 2021. The next case is SC appeal 4 stroke 2014, decided on 15th September 2020.
2015. Not 14, 2015.
SC Appeal 4 of 2015 decided on 15th September 2020 and SC Appeal 54 of 2015 decided on 5th July 2023.
Yeah, thank you.
So there is a follow-on question with regard to the settlement decree
Yeah.
as to when the settlement decree is filed, what happens to the decree absolute or the decree nisi?
No, that is where the skills of the counsel come into play. We do it in the district court also in other cases. We say if then we say the defendant will pay in installment, first one, second one, or third one, or something. Then you say if the defendant fails to pay one or more of the installments referred to above, then the plaintiff is entitled to execute the decree as referred to in the order nisi, which was made absolute. So because then you settle it for a lower sum, then you say if you default, we are entitled to execute the decree which was made absolute.
Right. So that flexibility is there because it's
No,
by consent of parties.
it's the talent of the lawyer, and you should know how to draft the terms of settlement.
Yes.
Yeah. Now there was I can remember there are instances where certain lawyers draft it saying we say 5 installments you must pay this and various things. So then the other defendant is may try to pay first one, then default the second one, then pay the third one, then default the fourth one, and like that. So that is why we say if you default one or more.
Yes.
So the moment you default, the entire thing triggers. And also we say we drafted it in such a way that we say if you pay this amount, we consider it as having having satisfied the decree nisi or decree which was made absolute. So if you don't, you pay the total sum. So it's a matter of how you draft terms of settlement. Any question? Anyone wants to answer questions in Sinhala? You may ask that.
සිංහල භාෂාවෙන් ප්‍රශ්නයක් ඉදිරිපත් කරන්නට අවශ්‍යතාවයක් තියෙනවා නම් මේ Zoom තිරේ raise hand නැත්නම් අත පෙන්වලා තියෙන icon එකක් තියෙනවා. ඒක එබොත් එතකොට අපිට අවස්ථාව දෙන්න පුළුවන් ප්‍රශ්නයක් අහන්න. එහෙම නැත්නම් Q&A option එකේ යටතේ ප්‍රශ්න ඉදිරිපත් කරන්නත් පුළුවන්. සිංහල භාෂාවෙන් type කරලා ඒකේ අලවල එවන්නත් පුළුවන්.
Sorry, I am unable. I won't be able to answer anything in Tamil, but that is the only thing I can do. Sorry about it.
There also, sir, and the participants, Isuri just informed me that they are able to send all the participants because their email addresses have been registered. They will be sending the judgments you have referred to, sir, to all the
that's very good.
participants for their.
Yeah, very good.
Yes.
Very good.
So they have it with them.
Yeah.
Also, sir, and I think one of the more progressive approaches I think you have taken in with regard to Debt Recovery Special Provisions Act and its interpretation, sir, is as you referred to expanding the discretion of the court under Section 6 to give unconditional leave to appear and defend. But if I may ask you the question, sir, that actually up to that point, no one had taken that departure. What prompted you to take that departure into that area of judge-made law?
I'm a people's man. No, because I felt there are a lot of uh, hardships for the litigants, and also there are these finance companies are abusing this legislation. Actually, if you really take it, that is the intention of the legislature. Though we all say it's a dracuna piece of legislation, but if you look at it, and also there is a tendency, if the law has very stringent provisions, the courts will interpret them in a more lenient manner, unless it is essential to interpret such matters to give a strict interpretation of the act. But anyway, I felt that this act permits the court to consider that aspect, and otherwise, this is it's impossible. We say if uh, uh, for a defendant who has defaulted, there are a lot of genuine people who have taken loans, but they are unable to pay it. So if they are asked to pay the total sum, so what's the use of having litigation? So they are unable to pay. That is why they have defaulted. So then the other one is then because now, but the courts, before I delivered this judgment, courts were also taking a lenient view. Initially it said you have to
Full
deposit the
sum.
total sum, then it's reduced to 50%, then 1/3, and now it's a discussion of court.
And if I may also venture to ask you, sir, in your rationale, the discretion of court to grant unconditional leave to appear and show cause would be if there is a strong defense that has been set up in the application to appear and show cause. Would that be correct?
Yes. That is why the act itself says you must have a. It says. But before that, I will say this is the question that you posed earlier. Section 4.3, what you asked the question, what happens whether they can come and file proxy and ask for a date. This Act
Yes.
4.3 says the day to be inserted in the decree nisi as the day for the defendant's appearance and showing cause, if any. So then technically this presupposes a situation where they will come with the papers and support the application, but in practice, the courts are more lenient. So even if you take the civil procedure code, though on the first date we file proxy and ask for a date, if the judge wants, the judge can say no. On the very first day, you have to file the answer.
Application.
File the answer in a
Sorry,
regular
answer,
action.
yeah,
Yes.
in a regular action. Yes.
Yeah. It doesn't say that you can file
Yes.
proxy and move dates.
That is right. Although in practice, that is what happens.
Yes. And also that's a discretion of court. Yeah. So what is the question that you sorry, I forgot.
No, what I was asking you, sir, is that in the event that court exercises its discretion to allow a party to appear and show cause unconditionally, that discretion
Just
could
a
be
minute,
used
yes.
only
That
in
is
very
section 6, no? Hold on.
section 6, sir.
Yeah.
6.2, sir.
Yeah. So this 6.2 says the court shall, upon the filing of the filing by the defendant of an application for leave to appear and show cause supported by affidavit, we shall then these are the operative words, which shall deal specifically with plaintiff claim and state clearly and concisely what the defense to the claim is and what facts are relied upon to support it. So those are things that you must put forward and satisfy court that you have a matter to be looked into. That is why now then C says, upon the court being satisfied on the contents of the affidavit file that they disclose a defense which is prima facie sustainable.
That's right.
And on such terms. That is why you don't need to prove that you have your defense, but you satisfy court that there is a sustainable prima facie defense, that you should be able to sustain that till the end of the case. So if you show that there is a sustainable defense, then the court will grant you permission.
Yes.
So that comes in C. That is where it says otherwise as the court thinks fit. So that is why I interpreted it to say that the court has discretion to allow them to appear without depositing security. So they have to establish that there is a sustainable defense. C. Upon the court being satisfied on the contents of the affidavit of a file, that they disclose a defense which is prima facie sustainable.
Yes.
So then you can say free, or you deposit 10%, 50%, or if there is nothing, you deposit the total sum. But the court can't say, no, we are not going to allow you to appear in the case. The court has to allow. Then what happens is the court has the discretion to decide on the quantum. But if there is no proper application, they can straight away, or they don't appear, straight away decree nisi will be made absolute. It's the same procedure applies like in the plaintiff's case. Defective application in both instances will be thrown out.
I'm just checking.
So the other thing is we need to be careful.
Yes.
You must not have prolix. It has to be concise application. You put it in to the point. You don't go on and on and on and on. Sometimes certain paragraph, it goes to 50 paragraphs, 60 paragraphs, not like that. So they have specifically mentioned you put it in a concise manner.
Sir, I think you touched on this. There is a question sent to us in Sinhala. You touched on this briefly in your speech, in your talk earlier, but I think we might have to reiterate that. And sorry, when we were discussing this topic, I think you spoke about this. It says, document ekaka waradak tibenawa nam e bava kiyamin දිවුරුම් ප්‍රකාශයක් ගොනු කර එම දිවුරුම් ප්‍රකාශය සමග කේස් එක ෆයිල් කරන්න පුළුවන්ද සර්? උදාහරණයක් ලෙස දිනයක් වැරදි ලෙස loan agreement හි සඳහන් කර තිබීම. I believe the question is, sir, if the loan agreement has a wrong or has an error in it, then you disclose that in your affidavit and you file the case. Is that possible? That's what he is asking, he or she.
මට මගේ මතය අනුව නම් එහෙම කරන්න බෑ. ඒ ඩොකියුමන්ට්ස් වල තියෙන වැරදි ඩෙට් රිකවරි කේස් එකකදී හදන්න බෑ. හැබැයි ඒකක් නිකන් රෙගියුලර් ඇක්ෂන් එකකදී කරන්න පුළුවන්. එහෙම වැරදීමක් තියෙනවා නම් ක්ලැරිෆිකේෂන් එකක් දෙන්න පුළුවන්. මොකද මේ අපි ඉස්සෙල්ලා සාකච්ඡා කරපු විදියට ගිවිසුමක් ලිඛිත ගිවිසුමක් තියෙන්න ඕනේ නඩුවක් ෆයිල් කරන්න. ඒ ලිඛිත ගිවිසුමේ යම්කිසි දෝෂ තියෙනවා නම් එතකොට ඒ ගිවිසුම ගැන ප්‍රශ්නකාරී තත්ත්වයක් ඇති වෙනවා. සමහර වෙලාවට ඒ ගිවිසුම එදා අත්සන් කරාද දන්නේ නැහැ. එහෙම නැත්නම් නිකන් අත්සන් අරගෙන පස්සේ දිනයක් දැම්මද දන්නේ නැහැ. ඒක නිසා තමයි මේ 4.1 කියලා තියෙන්නේ උසාවියෙන් බලන්න ඕනේ කියලා ඒ ලේඛන වල වෙනස් කිරීම් කරලා තියෙනවද මකලා තියෙනවද ඒවා එහෙම නැත්නම් සෑහීමකටපත් වුණොත් තමයි මේ ඩික්‍රි නයිසයි එක ඉෂුව කරන්න පුළුවන් කියලා. එතකොට ඩොකියුමන්ට් එකේ තියෙන වැරද්දක් අපි ඒකපාර්ශ්විකව හදන රේඛනයකින් කරන්න බෑ. උදාහරණයකට අපි කියන්නකෝ මෝගේජ් එකක වැරද්දක් තිබුණොත් අපි ඒක කරන්නේ රෙක්ටිෆිකේෂන් එකකින්නේ. ඒ රෙක්ටිෆිකේෂන් එක දෙගොල්ලම අස්සම් කරනවා. ඒක එක්කෙනෙකුට අස්සම් කරන්න බෑ. එහෙම නැත්නම් ලෝයර්ට විතරක් හදලා ෆයිල් කරන්න බෑ. ඒ වගේ ඇග්‍රීමන්ට් එකකත් වැරද්දක් තිබුණොත් ඒක එක්ක දෙපාර්ශ්වයෙන්ම කැමැත්තෙන් හදන්න ඕනේ. එහෙම නැත්නම් මේ වගේ නඩුවක කරන්න බෑ. හැබැයි ඒක මේ රෙගියුලර් ඇක්ෂන් එකකදී ඒක කියලා ඒක පැහැදිලි කරන්න පුළුවන් මේක වැරද්දක් වුණේ කියලා. දැන් සමහර වෙලාවට දැන් මම ලියන්න ගියත් 2025 කියන එක මට අමතක වෙලා 2024 කියලා ලියවෙනවා. විශේෂයෙන්ම ජනවාරි පෙබරවාරි මාසවල ඒක අපි ඔක්කොන්ටම වෙන දෙයක්. අවුරුද්ද වෙනස් වෙච්ච ගමන් චෙක් කොලයක් ලියන්න පොතක් ලියන්න එකක් ලීෆ් එකක් ලියන්න ගියත් ඒක වෙනවා. ඒ වගේ එකක් හැබැයි අර සාක්ෂි දීලා තමයි වෙනස් කරන්න වෙන්නේ මේක මේ වැරද්දක් වුණා. එතකොට කවුරු හරි ලියපු කෙනෙක් ඉන්නවනේ දිනේ දාපු කෙනෙක් එයාට ඇවිල්ලා කියන්න වෙනවා මේක මගේ වැරද්දක් වුණේ කියලා. එහෙම නැතුව මට හිතන විදියට එහෙම කරන්න බෑ. මේ debt recovery file කරන්න බෑ.
I think the question also was මම හිතන්නේ සර් මේකේ ප්‍රශ්නේ එක වුණේ දැන් ඒ වැරද්ද කාගේ හරි අතින් නම් සිද්ධ වුණේ ඒ පුද්ගලයාත් ඇෆිඩේවිට් එකක් මේකට අමුණලා ඉදිරිපත් කරා නම් ඒකෙන් මේ ප්‍රශ්නේ කියන්නේ ගොඩ යන්න පුළුවන්ද පැමිණිල්ල
මම හිතන්නේ මගේ මතය අනුව එහෙම කරන්න බෑ. එහෙම කරන්න බෑ මොකද debt recovery law එකේ එහෙම provision එකක් නැහැ. ඒ කියන්නේ පොඩි හරි වැරදි තියෙන ලේඛන ටික 100% හරියටම තියෙන්න ඕනේ. දැන් සමරි ප්‍රොසීඩිය එකේ වුණත් චෙක්ස් වල එහෙම හරියටම තියෙන්න එපා. ඒක ප්‍රසන්ට් වෙලා තියෙන්න ඕනේ නියමිත කාලෙදී හරියට වැටලා තියෙන්න ඕනේ. ඒක ඒවයි වැරදි හදන්න බෑ මේ සමරි ප්‍රොසීඩිය වල වැරදි හදන්න බෑ. කොල සෙට් එක හරියටම තියෙන්න ඕනේ. මොකද ඒක නිසා තමයි අර ඕරල් එවිඩන්ස් උත් බෑ කියන්නේ. ඉන්ක්වයරි මේ ලීව් ග්‍රාන්ට් කරන වෙලාවේදී අමතර කොල දෙන්නත් බෑ.
Then sir there is an interesting question. One of the attendees would like to know what your idea of a reasonable defense would be for a defendant to be able to take in an application to appear and show cause.
Reasonable defense is that is why I said in the section itself says it should be a sustainable defense. So then the court will see, go through they will evaluate the document, the affidavit and the documents filed by the plaintiff and the application filed by the defendant along with the affidavit and other documents and evaluate and see whether there is a sufficient, whether there is a acceptable defense. For an example, we say you never signed that document. Then you say, no, this is not mine. And then you, I never, on this date, I was not in the country. You submit your passport and say, though they have filed, I was not in the country. Or you say that the alleged cause of action is prescribed. So those are otherwise what happens is generally a lot of defendants, they just come up with a bare denial. Excuse.
If there are
Sorry.
any more questions, you
Sorry,
can.
because it should not be now. For an example, when I was also as a junior practicing in the district court, we used to do a cut and paste. You just take we had set defenses. You would copy that and paste it in your answer. So that won't do with this act. You have to say whatever. You have to come up with your exact defense. You can't just file some defenses or denials and then ask permission of court.
Right. So I think we are at the end of the Q&A.
So they have either understood or they have not understood or they have not.
One out of the
not
two.
This is a useless
Fully
thing.
understood or didn't understand at all. Anyway, sir, I'm extremely grateful to you, and it has been an absolute pleasure moderating this webinar with you as the speaker, and to tap into your wealth of knowledge, and particularly your very progressive thinking as a judge and the judge-made law that you brought about during your tenure on the bench of the Apex Court. Whilst we thank you, and I thank you for obliging the Bar Association in being our resource person for this webinar. I'm sure all the participants have benefited immensely. I too benefited in tapping your brain on this topic. And I thank you very much, sir, for sparing your invaluable time for us. And we wish you all the very best in all of your endeavors.
Thank you very much for having me on the program. And I hope everyone benefited in some way and it's not a waste of time. Thank you very much.
Over to you, Isuri. Thank you.
Thank you, sir. This brings us to the end of the 5th webinar on the series on basics of law titled Money Recovery under the Debt Recovery Special Provisions Act number 2 of 1990 as amended. I thank our esteemed panelists, Justice Priyanka Jayawardena, President's Counsel and former Justice of the Supreme Court, and our moderator, Mr. Shahan Gunawardana, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this webinar. But last but not least, I thank all of you who have joined us in for this session today through various platforms, including Zoom and YouTube, and for the interactive discussions that we've had. Thank you, and I hope you all have a very good night.